Good morning. I am Jayashree. Welcome to Institute of Sai. We are going to start with service of summons. The subheading under order 5. Okay. Service of summons. Rule 9 of order 5. Order 5, rule 9. Delivery of summons by court. Here in this subheading, we are going to read about the service of summons. Okay. So, rule 9, delivery of summons by court. We already know that summons has been issued and the summons it has to be served upon, right? So when we are dealing about the delivery of summons, we have already seen it can be by an officer of the court or through post, correct? We'll go further with this. Where the defendant resides within the jurisdiction of the court. That's what we were doing. Yesterday I had just started with it, but due to some inadvertent circumstances, I had to stop it in between, so I am restarting it. Wherever the defendant is within the jurisdiction of the court, the summons shall be served by the jurisdictional court itself. Okay, so we'll just go through it once. Where the defendant resides within the jurisdiction of the court and has an agent residing. So, where either the defendant or his agent is residing within the jurisdiction of the court, then the court shall serve the summons either on the defendant. If defendant is within the jurisdiction, then obviously the court will serve it on the defendant. Okay. But if the defendant is not within the jurisdiction of the court, then it can also be served on the agent, provided he is the authorized agent. If he is the authorized agent, then it shall be deemed as if the summons has been served on the defendant. Okay. Then we go to sub-rule 2. The proper officer may be officer of a court or it can further be delegated to his subordinate. Okay. Then rule 3. The services of summons may be made by delivering or transmitting a copy thereof by register post acknowledgement due. Okay. So register post acknowledgement due, either it can be served by the officer himself or subordinate of the officer, that is through court. That's how we call it in the practical right? Practical scenario. So it can be either through court, that is through any of the officers of the court, whom in Karnataka we call as Amina. Okay. Then or it can be as per sub-rule 3. The summons can be served upon by way of register post acknowledgement due. But I think you must be knowing, after that we have the email also. Nowadays, due to pandemic, email service of notice is also recognized. Courier service is also recognized in some places, not all places. Otherwise, it is only speed post and RPAD which is usually done. If we have to send it through court, then it is only through RPAD. Okay. Or speed post or by such courier services as approved by the High Court or by the court referred to in sub-rule 1, or by any other means of transmission of documents including fax message or electronic mail services provided by the rules made by the High Court. So what are all the ways of service of notice? Through court, that is through the officer of the court or through his subordinate, number 1. Number 2, RPAD, that is register post acknowledgement due. 3, speed post. 4, courier service. 5, email. 6, fax message. Okay. Then that's all. Okay, so any way of transmitting, either it can be through electronic or non-electronic means, but however it is, the summons has to be served on the defendant. Okay, all this fax and email and all that has come up recently. It was not there earlier. Provided that the service of summons shall be made at the expense of the plaintiff. Plaintiff has to pay the process fees. Am I right? Okay. Then sub-rule 4, notwithstanding anything made under sub-rule 1, defendant resides outside the jurisdiction of the court. Then what should the court do? We have already read it. The court has to send the summons to the jurisdictional court where the defendant resides or works for gain or carries on his business. Correct? So the the summons has to be sent to the other jurisdictional court where the defendant resides. and that court will be the jurisdictional court for the purpose of service of such I'm sorry, and that particular court shall be the jurisdictional court for the purpose of service of summons. Okay. Then rule 5, where an acknowledgement or other receipt purporting to be signed by the defendant or his agent is received by the court, or the postal article containing the summons is received back by the court, and an endorsement purporting to have been made by a postal employee or other person authorized by courier service or containing the summons or had refused to accept the summons when tendered or transmitted to him, the court issuing the summons shall declare that the summons has been duly served on the defendant. So when shall it taken to be duly served on the defendant? Whenever he has refused to take it, okay, or he has returned the summons along with the copy thereof, okay. Where it has been written, see, if the defendant is not found, clear, either he is out of station or he is not found, he has vacated the place, then it shall not be deemed as served, okay. But where he has refused to take it, or he has returned voluntarily, he has returned all the summons back to the court, then in that case it shall be deemed to be that it has been duly served on him. Of course, we have another this thing where it says wherever the adult member of the family of the defendant has been served, it shall be deemed to have been served on the defendant, provided the adult member should stay along with the defendant. That is one more cause for concern. Okay. Provided that where the summons was properly addressed, prepaid and duly sent by register post acknowledgement due, the declaration referred to in subrule shall be made, notwithstanding the fact that the acknowledgement having been lost or mislaid has not been received by the court within 30 days from the date of issue of summons. Even though the defendant has accepted it, but the court has not got back the acknowledgement due, it is okay. Since the defendant has received it, it is taken to be due service of summons. Subrule 6. High Court or District Judge as may be shall prepare a panel of courier agencies for the purpose of Subrule 1. Subrule 1, what does it say? Courier service, service of summons through courier service is also valid. Right? So for that, what is the power given to the High Court or the District Court? They can pinpoint, these are the few courier agencies through whom summons can be sent. Okay. Then we go to Rule 9A. Summons given to the plaintiff for service. See, till now we read about giving it to the court for service of summons. But here what is it? The court is giving the summons to the plaintiff to be given to the defendant. This is known as hand summons. Okay. We call it as hand summons. The court may, in addition to the service of summons under Rule 9, on application of plaintiff for issue of summons, shall in such case deliver the summons to such plaintiff for service. The service of such summons shall be effected by or on behalf of such plaintiff by delivering or tendering to the defendant personally a copy thereof. That's why I said hand summons. Just keep it in mind, hand summons, because once we say hand summons, you know that it is being personally delivered. Okay, so it is easy to remember all that. Okay, so it is personally a copy thereof signed by the judge or officer of the court. It is given to the defendant, served on the defendant. The provisions of Rule 16 and 18, we will go through it later, shall apply to a summons personally served under this rule as if the person effecting such service was a serving officer. See, when we are talking about the plaintiff, he is a party to the case. Am I right? He is party to the suit. He cannot be deemed to be a register postal employee. Not register post, even if it is speed post. He cannot deem to be a postal employee, nor a courier agent, nor a employee of the court, officer of the court, right? Or subordinate of the officer. Clear? So it is not to be deemed that he is such but the act that he is doing is deemed to be that of service of notice. Clear? Later, the defendant cannot come to the court and say, no, I was served by the plaintiff, not by the court, or not by RPAD, not by courier service. He cannot take up such defense. Rule 4, Sub-Rule 4, If such summons, when tendered, is refused, or if the person served refuses to sign, the court shall, on application of party, reissue such summons. Where I already told you in the previous rule, it may be certain cases where the defendant is not available. Okay, in such cases, therefore, the summons gets returned to the court. Then it shall not be deemed to have been served on the defendant. Okay. So in such cases, what will happen? There will be a reissue of summons by the court. They will try once again to see if it can be served on the defendant. Okay. Then next we go on to Rule 10, Mode of Service. Service of summons shall be made by delivering or tendering a copy thereof signed by the judge. What is mode of service? We have already done the modes of service. Am I right? So, but what is important? It should be duly signed by the judge or the authorized officer of the court. Okay? There should be a seal of the court. See, signature can be that of the officer, but there should be a seal of the court. Rule 11. Service on several defendants. See, sir, whether it is one defendant or several defendants, service of summons, the rules regarding service of summons is the same. Okay? As regards the modes of service, how it should be served, what should be there in the summons, it should be signed, sealed, all that, as well as the modes of service, RPAD, etc. Okay? And what are the rules when it comes to return of the summons, whether it is voluntarily by the defendant or involuntarily because he is not there at home or something like that. Okay? Everything will be the same, even if it is several defendants. Then, Rule 12, service to be on defendant in person when practicable or on his agent. We already read it, right? So, wherever it is practicable, wherever the defendant is within the jurisdiction, or even if he is not within the jurisdiction, if we can send if the court can send an RPAD, court in the sense the party, am I right? If we can send an RPAD or a courier or a speed post or something like that, email anywhere in the world we can send, right? So, see, one thing, when you're reading all these things, you should be a little practical in your outlook. Okay? Don't go too much into the by-hearting types, that's not going to help you in any manner. Okay? Except for sections, orders, rule numbers and all those things. Those numbers and all that you need to know. Sections, how many sections are there, which are the sections, what they are, all these things you can by heart, absolutely no problem. But when it comes to certain questions, you need to analyze. See, for example, here we say Rule 11, several defendants, service to several defendants is the same. So you cannot say only about the issuing of summons by RPAD or speed post or whatever. It has to combine right from issuing up to service of summons and returning back to the court. Clear? Same way, Rule 12 also, service to be on defendant in person when practicable or on his agent. It is not necessary that he should be within the jurisdiction, right? He can be within the jurisdiction or he can be away from jurisdiction, but where he can be reached in such manner. It can be RPAD also. Even if he is residing away from jurisdiction, he can be reached via RPAD or speed post or email or fax message. Am I right? So that can be taken up. If he is within jurisdiction, then summons can be sent through court itself. Through the officer of the court. Rule 13, service on agent by whom defendant carries on business. That's what we already read. Wherever it is a question of the authorized agent, he has been authorized to receive summons, appear on behalf of the defendant, anything, when he has a GPA, general power of attorney, am I right? Or his agency agreement is such that it covers everything. Correct? So, in all such cases, the agent, even service of the summons on agent shall be deemed to be sufficient service. Okay. Then rule 14, service on agent in charge in suits for immovable property. Wherein a suit to obtain relief respecting or compensation for wrong to immovable property, service cannot be made on the defendant in person, and the defendant has no agent empowered to accept the service. It may be made on any agent of the defendant in charge of the property. So what is important here? Just underline in charge, agent in charge of the property. Please underline that. Okay, agent in charge of the property. So where the defendant is not within the jurisdiction, okay, and he has no such agent whom he has authorized to collect the summons, that's also not there, then he can be served on any of his agents, provided that particular agent is in charge of the immovable property, which is the subject matter of the suit. Please remember. Okay, it should be the subject matter of the suit, and that person should be the agent for that particular immovable property. Then service of summons on such agent shall be deemed to be sufficient service. Okay. Then rule 15, where service may be on an adult member of defendant's family. I told you some time back, am I right? If the defendant is not there, then an adult member who is residing along with the defendant, okay? Adult member of the defendant's family, don't take it verbatim. Okay, so if the adult family is staying somewhere else, defendant is staying somewhere else, and the summons is given to the adult family. Suppose the adult member does not have any contact with the defendant, then it is deemed to be different. See, if a defendant is a son or daughter, and if it is served on the parents, it's okay, because there will be communication. That is the main aim. Okay, why it is said that adult member of defendant's family can be, there should be sufficient communication. Therefore, the defendant should be can be easily assumed to have known about the service of summons. Okay, if I am sending summons to one party, okay, even though he is residing somewhere else, or he is not in station at that particular time, whatever it is, but if I am going to serve the summons on his parents, obviously the parents will communicate to him, am I right? So there is sufficient service. What is the main aim? Defendant should know that there is a case which has been filed. That's it. Okay, against him. Where in any suit the defendant is absent from his residence at the time when the service of summons is sought to be effected on him at his residence, and there is no likelihood of his being found in the residence within a reasonable time, and he has no agent empowered to accept the service, service may be made on any adult member of the family, whether male or female, residing with him. Okay. A servant is not a member of the family within the meaning of this rule. You should remember this very well, because sometimes what happens, servants reside in the same residence. Am I right? So, and that servant obviously will be a major. So, it doesn't mean I have served it on an adult member in the defendant's family. Okay. Because he is not part of the family. I'm sorry. Then we go to rule 16. Person served to sign acknowledgement. Whoever is receiving the summons should sign on the acknowledgement. So it can be either the agent or the defendant himself or any adult member of the defendant's family. Okay. Then rule 17. Procedure when defendant refuses to accept service or cannot be found. Where the defendant or his agent or such other person refuses to sign the acknowledgement, underline refuses to sign the acknowledgement, or where the serving officer, after using all due and reasonable diligence, cannot find the defendant. Number 1 is refuses, underline that. Number 2 is cannot find the defendant. Okay, who is absent from his residence at the time when service is sought, and there is no likelihood of his being found in the residence within reasonable time. We have already seen it. There is no agent. Number 3, underline no agent empowered. Number 3, underline that. There is no agent empowered. So what you will underline? No agent empowered to accept service of the summons, nor any other person on whom service can be made. What's 4? 4 is any other person on whom service can be made. Okay, so underline that nor. Why? Because that is the 4th one. There is no person. That means what? No adult member also. Okay, the house is locked, or nobody else is there and all that. Okay, nor any other person on whom service can be made. The serving officer can affix the copy of summons in a conspicuous place. Conspicuous means what? Where we can very easily see. As soon as I enter, probably the compound. Right? Compound is the most common place. It can be the compound. Sometimes some houses don't have compounds. So what will happen? It will be the door, or maybe the wall near the door. Something like that, But where, as soon as you see, as soon as you look at that direction, you will know that there is something which is stuck there. Conspicuous. Okay. Okay, conspicuous part of the house in which the defendant ordinarily resides, carries on business, or personally works for gain. Okay, and shall return the original to the court. So what shall be stuck there? Photocopy. The true copy of the summons shall be stuck on the conspicuous place, and the original shall be returned to the court with a report endorsed thereon, saying that I have affixed it because the defendant could not be found, or there is no adult member, no agent. Okay, so that acknowledgement should be there. That's a part of the report to be filed. Okay, then next, Rule 18, endorsement of time and manner of service. Who has to do this? The serving officer, because he will know when he served the summons, okay, and in what manner he served the summons. Okay, so the serving officer here, when you are saying service officer, it can be the postal employee as well. Okay, the serving officer shall in all cases in which the summons has been served under Rule 16 endorse or annex, or cause to be endorsed or annexed or to the original summons, stating the time when and the manner in which summons was served, and the name and address of the person, identifying the person served, and witnessing the delivery or tender of summons. Okay, so there shall be signature of the person who has received the summons. Okay, and the person who has witnessed the delivery. But usually, it is only the person who receives the summons signs it, because we cannot go in search of witnesses and all that. So the person who is receiving the summons signs it, and the serving officer has to endorse upon it, saying that the summons was served on so and so person at this time and in this manner. Okay, then next we go on to Rule 19, examination of serving officer. See, wherever it is required, okay, where a summons is returned under Rule 17, that means what? It is affixed. Correct? It is affixed, and the serving officer says it has been affixed, and he gives the original to the court. If needed during the evidence stage, the serving officer shall be called upon as a witness to speak about the manner of service and what he found there. All that report, whatever he has to given to the court, that can be taken as evidence. If necessary, the court can call upon the serving officer. Then Rule 19A, simultaneous issue of summons for service by post in addition to personal service. This was there earlier, but it has been omitted. Earlier we used to do both. It was like we used to give for process memo also, we used to give by RPAD also. I mean both ways, for personal summons as well as this, but it has been omitted. Then Rule 20, substituted service. Where the court is satisfied that there is no reason to believe that the defendant is keeping out of way for the purpose of avoiding service, underline avoiding service, or that for any other reason the summons cannot be served in the ordinary way. So what you will underline? Avoiding service, underline. Okay. Next, cannot be served in ordinary way. Please underline. Cannot be served in ordinary way. The court shall order the summons to be served by affixing a copy thereof. We have already done that. Am I right? Affixing a copy thereof in the conspicuous part of the house or the place of work or the business place. Okay. Of the house, that's what, usually they go to the house and affix it. In which the defendant is known to have last resided or carried on business or personally worked for gain or in such other manner as the court thinks fit. Okay. So where, see, sometimes what happens, before filing the case, the defendant may be residing in one particular place or working for gain or doing business or whatever. But when we when we file the case suit, and then we come to know that the defendant no longer resides in such place, then what can happen? A fixture can be done on that particular place where he used to reside ordinarily. Okay. It should not be a very rare place where he comes once in a while and goes. Ordinarily resides or ordinarily works for gain or ordinarily carries on business. Okay. That ordinarily is very, very important. Then, subrule 1A, where the court acting under subrule 1 orders service by an advertisement in the newspaper. So first is what? Affixing in a conspicuous place. Rule 1A speaks about what? Advertisement in newspaper. Underline please. Advertisement in newspaper. And what sort of newspaper it should be? Daily newspaper. Okay. And one in English language and one in vernacular language. Then subrule 2, subrule 2, effect of substituted service. Wherever there is a substituted service is used, it shall be deemed as if the summons has been served on the defendant. Subrule 3, where service substituted, time for appearance to be fixed. Where the substituted service, either newspaper, via newspaper the advertisement has been given, the summons has been deemed to have been served via newspaper or by way of substituted service, then sufficient time shall be given for the defendant in that particular place itself. If it is a newspaper ad, write in the ad itself, so and so, that's the date of appearance, please come. That is how. Okay, not please come, you should appear. Okay, so that is what subrule 3 says. Next we go to rule 20A. Rule 20A, service of summons by post. It has been repealed. We already saw that, right? It can be by register post acknowledgement due or speed post, correct? Of course, courier service and all that have been included later on. So rule 21. Service of summons where defendant resides within jurisdiction of another court. A summons may be sent to the court by which it is issued, whether within or without the state, either by one of its officer or by post or by courier service. We have already dealt with this in the previous sections, right? So it shall be sent to the other court. Okay. If the defendant is residing away from the jurisdiction of this particular court where the suit is instituted, then summons can be served on the defendant by the jurisdictional court where the defendant resides. And how shall the service be sent? It shall be by post or courier service or fax or email or officer or one of his subordinates. Everything remains same to same. Okay. Only thing, instead of the court where the suit is instituted, it is the court where the defendant resides which will be serving the summons on the defendant. I hope you are clear with all these things. It is quite easy. There is nothing much to do. So we'll continue with the next section in the next session. Okay. Thank you.